A very pleasant evening to everyone. The Lex Discourse team welcomes you all to its fifth webinar. Today, we are delighted to have Advocate Avinash Deshmukh sir to enlighten us on basics of service litigation. Advocate Avinash Deshmukh sir is a practicing advocate at the Bombay High Court's bench at Aurangabad since last more than 3 decades. Starting as a bright dynamic student, he held merits in all streams of academics. In the arena of practice, he holds his authority in terms of knowledge in service, administrative, and constitutional law. Sir is recognized as subject expert in the matters before the Maharashtra Administrative Tribunal. He has also represented Class 1 officers in the matter relating to service litigation. Before the session starts, I would like to inform our attendees that this webinar will be followed by question and answer session. Attendees who are attending the webinar through Zoom can raise their questions in the chat box, and the attendees on our YouTube channel can raise their questions in the live chat option. I request Sir to please begin with the session. Over to you, Sir.
Thank you, Ashita. A very good evening and a namaskar to one and all. In these extraordinary difficult times of pandemic COVID-19, I hope that you are all staying home and staying fit. I wish that you all continue to do that because we have to face this pandemic. At the outset, I thank the Lex Discourse team for affording me an opportunity to share with you all some of the basics of service litigation and the procedure relating to it. Friends, the field of service law, though is an extremely niche field, it cannot be viewed in isolation, in my opinion. And for its holistic understanding, one must acquire a stronghold on the administrative law and the constitutional law, which are both the branches of public law as distinguished from the private law. In the beginning, before tracing in brief the development of service litigation in India, I may tell you that in common parlance, though service matter or service litigation may apparently mean and convey that it has only got to do something with an individual's service or his service conditions after entering service. However, we must keep in mind that even a layperson's matter or a litigation in relation to recruitment or entry in a particular service is also a service matter. Meaning that even if a person is not in service and is a commoner, still, if he or she is aggrieved by some process of recruitment in which he or she had participated, then the litigation initiated by him or her is also a service matter. So these basic things are to be kept in mind. I may also state here that at present, service matters are heard in various courts or tribunals, like the high courts, the administrative tribunals, and even the labor and industrial tribunals. If we briefly consider the development of service law in our country, it is seen that up to the 1960s or early 1970s, the service litigation was comparatively less. And the remedy being availed, therefore, was filing of a civil suit. Thereafter, the aggrieved party had the remedy of preferring an appeal before the Bombay High Court and then before the Supreme Court, if required. Later, however, the remedy of filing of a writ petition under Article 2 to 6 of the Constitution before the High Court was being used. But that led to a tremendous increase in the service litigation. That state of service litigation was to such an extent that various high courts soon were finding it difficult to cope with such a burden of matters. And as a result, the fallout was that for the period required for final disposal of these matters became quite long, extended even to years. So appreciating this situation and considering that into consideration, the Parliament in the year 1976 introduced Articles 323A and 323B in the Constitution, which provided for establishment of administrative tribunals and also other tribunals for like the matters of taxes, then foreign exchange, then industrial and labor disputes, like and other subjects. Since the scope of our discussion today is related to service law, it is only Article 323A which comes in picture. As I said, after the Amendment Act of 1976 was there, in the course of time, and that took about 9 years, the central government enacted the Administrative Tribunals Act in 1985 in exercise of the powers conferred by Article 323A, thereby providing for establishments of the tribunals at the central and the state level. So one thing which we must keep in mind here, that as far as these tribunals, even the Central Administrative Tribunal or the State Administrative Tribunal is concerned, these are the creatures of a statute because they exist, they owe their existence to the Act, the Administrative Tribunals Act, unlike the High Courts and the Supreme Court, which are the constitutional bodies and which owe their existence to the Constitution itself. After the Administrative Tribunals Act was brought into effect by the central government, as I said, in 1985, the establishment, the Central Administrative Tribunal was established with its main seat at New Delhi and branches at various state capitals. Upon formation of these tribunals, the service litigation or service matters which were pending in various courts, like the civil courts or even the high courts, all those matters to transfer either to the Central Administrative Tribunal or to the State Administrative Tribunals, depending upon the person's appointing authority. Here, I want to particularly point out that in view of the provisions of sections 14 and 15 of the Administrative Tribunals Act, the jurisdiction, powers, and authority exercisable immediately before establishment of these tribunals by all courts, of course, except the Supreme Court, in relation to service matters were taken away. Result was that all courts, including the civil courts, which previously had the power and jurisdiction to entertain service matters, ceased to have that power or authority. This position was clarified in 1997 by the Lex Court in L. Chandrakumar's case, when it was held that the administrative tribunals were to act as the first instance courts in respect of service matters. And it was also said that the decisions rendered by these tribunals were open for being challenged before the respective high courts under Articles 226 and 227. Therefore, it is essential that we keep in mind that as far as the service disputes of employees and officers of the union or the state governments are concerned, respective administrative tribunals are required to be approached. But here, one interesting aspect is to be borne in mind that as far as the service matters of employees of the local self-governments, or in a state, for example, like the employees of the municipal corporations or municipal councils or Jilla Parishads, and those of other local bodies or authorities or statutory boards or corporations which are owned or controlled by the government, these employees are not able to approach the administrative tribunals. They are still required to approach the High Court for redressal of their grievance regarding the service matters. And the reason is that sections 14 and 15 of the Administrative Tribunals Act, which provide for the remedy to the employees, but there is a subsection in both these sections 14 and 15, which provides that as far as the employees and officers of the local self-governments and other boards or corporations, the appropriate government may by notification apply the provisions of the Administrative Tribunals Act to them. But the result is that unless and until this notification is issued The administrative tribunals are not in a position to exercise jurisdiction in respect of these employees of the local bodies or statutory boards or corporations. Here I may refer to the case of the state like Maharashtra, where the state government has already established an administrative tribunal. It started functioning way back in the 1991. But as on today, the state government has not issued any notification under subsection 2 of section 15. And as a result, the employees of the local self-governments, or as I said, the other statutory boards or corporations, they are not in a position to approach the administrative tribunals, and they are required to directly approach the High Court. So as it stands today, the High Court and the tribunal both are exercising jurisdiction in respect of service matter, but they exercise this jurisdiction in respect of different classes of employees. So this distinction is to be borne in mind. Another thing which maybe the young lawyers need to consider, keep in mind, is that when a decision of an administrative tribunal is challenged in the High Court, the power being exercised by the High Court is under Articles 226 and 227. And because of that, the matter goes before a division bench of the High Court, unlike in other service matters which reach the High Court through the letter of Administrative Tribunal, because those matters go before a single judge bench of the High Court. So what I would suggest is that whenever you are confronted with a situation wherein you have to decide as to whether a particular service matter lies before the Administrative Tribunal or before the High Court, what is required to be found out is that who is that person's appointing authority, what is the source of his or her pay, and which are the service rules governing him or her. This is because if the person's appointing authority is either the union or the state, and if he's getting his salary or pay from the consolidated fund of the state, then, and also if the service rules governing him are framed by the union or the state, then necessarily the jurisdiction lies with the administrative tribunal. But if not, then the remedy is before the High Court. At this stage, friends, I may point out that as far as members of the armed forces, the Army, Navy, and Air Force are concerned, they are excluded from the jurisdiction of the administrative tribunals. And the reason may be that because the Army has provided for an internal machinery for its own likewise, even the employees of Judiciary also, right from the Supreme Court, various high courts, and even the courts subordinate, all subordinate courts, their employees are also excluded from the jurisdiction of the courts, and they cannot approach directly the High Court. So they are required to, this aspect is required to be kept in mind, that the employees of armed forces and the employees of the judiciary, they're not in a position to approach the administrative tribunals. So these are the things which we are required to keep in mind as far as the jurisdiction of the tribunals is concerned.
Yeah. So as I was saying before some time, Section 2 of the Administrative Tribunals Act excludes the categories of employees from the armed forces and the judiciary. So they cannot approach the administrative tribunals, and their remedy lies before the High Court. As far as the next aspect is concerned in regard to the service matters, we are required to keep in mind as to what exactly encompasses service matters. So there are wide variety of matters are included therein. And then the categories begin with the very recruitment process itself. So there are matters concerning recruitment. Then once the person enters service, then there can be disputes about pay fixation, or even the promotions or then retired terminal benefits, transfers and postings. So various kinds of matters are involved, categories are involved. And these matters can be brought to the tribunal or can be brought to before the High Court. But here we are required to keep in mind one aspect, that if there are some personal disputes between employees inter se, or between an employee and his superior and his subordinate, then the such type of a personal nature dispute cannot be brought to the court or the tribunal. Matters of personal animosity cannot be brought before the courts, unless and until if that personal matter ultimately touches his service condition, it takes away some of his service right, then obviously the person gets the right to approach the administrative tribunal or the High Court. So this has also to be borne in mind, that matters of personal nature are not within the jurisdiction of the court. As far as service matters, as I said earlier, when you deal with service matters, there are a number of provisions contained in the Constitution of India which also come into play. Just by way of example, if I am to refer to certain provisions only, then there are Articles 14, 16, even Article 21 also. And the reason for, as far as Article 21 is that it is now known that Honorable Apex Court has repeatedly said that right to life and personal liberty includes right to livelihood as well. And so right to livelihood is obviously connected with the service. So if my service is being taken away, that leads to losing my right to livelihood, and ultimately it affects my right to life, and Article 21 is also attractive. So in this manner, like Article 14, 16, 21, then Article 162 is also attracted in some cases. Article 162 speaks about the executive power of the state, under which the state can issue orders, and these can be pertaining to the service matters, and they come into picture in service matters as well. Then there is Article 309, which confers power upon appropriate legislature to frame laws governing the service conditions, recruitment, and the like. In fact, to Article 309, there is a proviso, which says that till a legislature enacts law governing the recruitment or service conditions, till that time, it is permissible for the appropriate legislature to form rules for governing these service conditions. So this proviso under Article 309 also comes into picture in a number of matters. Then after 309, there is Article 310. 310 article is a very important article as far as service matters are concerned, because that speaks about the pleasure doctrine or the doctrine of pleasure. That article provides that the persons who are appointed either under the union or the state, they are appointed during the, or they continue to be in service during the pleasure of the president or the governor of the state, as the case may be. Meaning that it is permissible for the president or the governor to dispense with that person's service at any point of time, subject of course to following the procedure required therefore, or even if not the detailed procedure, then the procedure under Article 311, which is the next article which I was to refer to. Because Article 311 permits or it provides for certain contingencies under which the person can be dismissed or removed from service without following the due process of conduction of a departmental inquiry and the like. Another article of the Constitution which comes into picture in number of matters is Article 320. That article speaks about the public service commissions. And as we all know, there is Union Public Service Commission, there are state public service commissions. And these authorities, constitutional authorities, these are having the authority to select persons for being appointed in the union service or in the state services. So these are the articles which one must get acquainted with as far as while dealing with the service matters are concerned. Now, friends, we come to the powers of the courts or tribunals while dealing with the service matters. I would like to point out here that while dealing with these kinds of matters, the courts or tribunal, even the High Court also, and even the tribunal, they are exercising the powers of judicial review. And these powers are very different from the powers of appellate courts or the like. So what is a power of judicial review? In short, it can be said that in exercise of the powers of judicial review, the court is concerned only with the decision-making process and not with the final decision reached. And for the reason that it is not for the court or tribunal to substitute itself in place of the administrative authority. It is for the court only to take into consideration as to whether the decision which is being challenged before it, while reaching that decision, the legal right of the person concerned, whether any of his legal rights were violated, whether any illegality was committed, and that act is to be tested on the touchstone of the legal provisions. It is also to be seen as to whether there is an exercise of power in excess of the one which is conferred upon the authority. And as I said, there can't be any substitution of view by the court to the view of the administrative authority. I'll just give an example here that if in respect of a person in service, a departmental inquiry is conducted in respect of certain allegation against him, and the inquiry officer submits his report to the disciplinary authority, and the disciplinary authority, upon consideration of the inquiry officer's report, comes to a particular conclusion and imposes a punishment upon the person. Thereafter, that person, as I earlier said, the departmental remedies which are available under statutory provisions of law governing that person, he has those remedies. And then, if after exhausting of that statutory remedy of maybe an appeal or a revision, if thereafter also he is still aggrieved, then he can come to the High Court or the tribunal. When he comes before the court, there the power of the High Court or the tribunal is restricted. And it can only be seen as to whether, when the inquiry officer conducted the inquiry, whether he conducted the inquiry by following the due process required to be followed necessarily, whether he has breached any principles of natural justice, and whether the person was given every opportunity to defend himself. So this has to be taken into consideration. And if the court comes to the conclusion that before the inquiry officer there was some evidence, and on the basis of that evidence he has reached a particular conclusion, and the disciplinary authority has accepted his finding, then it may not be possible for the court to say that the inquiry officer was wrong in reaching this conclusion, or the disciplinary authority was wrong in accepting this finding. Yes, there is a course open for the court to interfere even in these matters of departmental inquiries. And the court can do so if it is a case of no evidence. So in a case, if it so happens that the inquiry officer has drafted the report, but in spite of the fact that there was absolutely no evidence before him, still the inquiry officer has reached a conclusion that no, the delinquent is guilty of the charges leveled against him. So this is a case of no evidence. And if this is so, then the court is certainly permitted to interfere and question the punishment imposed on this very ground, that it was a case of no evidence. Then it is also to be taken into consideration that, as I earlier said, the principles of natural justice, then mala fide, if the action is mala fide, though it may not be strictly speaking in violation of some provision of law, still it can be interfered. I'll just give here an example of the matters of transfer or posting. In these matters, it is only in this, I think that the state of Maharashtra is the one which has introduced an act regulating the transfers. But as far as other states are concerned, subject to correction, I feel that the field of transfers is governed by the government circulars or government resolutions which do not have the statutory force of law. So in such cases, if the person comes to the court and says that he has been transferred, and the reason for transferring him, if he is attacking the order of transfer on the ground of mala fides, it is certainly open for the court to interfere with these matters. It can be seen as to whether the action is mala fide, and if it is established on the basis of record before the court that the action was mala fide, it was not in the better interest of the administration, it was to serve some ulterior motive of somebody, then the court can certainly interfere in the order of transfer also. As I said, there are some limits to the powers of judicial review. But though there are these limitations, the powers of judicial review are quite wide enough, and to such an extent that in exercise of this power of judicial review, the High Court, and even for that matter, the Administrative Tribunal also can not only set aside an administrative order, but it can also set aside an executive order issued under Article 162 of the Constitution of India or any other subordinate legislation. Not only that, but even a statute or a law can also be set aside by the court in exercise of the powers of judicial review. So, as I said, there are limitations on the power, but as far as these aspects like questioning of the decision are concerned or statute are concerned, the power is wide. Only one thing it may have to be noted, that as far as the power of the High Court and the tribunal to quash any statute or law, though is akin, only limitation on the power of the tribunal is that it cannot test the virus of its parent act, that is the Administrative Tribunals Act, under which it is formed. So if at all any provision under the Administrative Tribunals Act is to be challenged, then it is required to be done only before the High Court, and the tribunal has no power to test the virus of that act, because it is its parent act, and as I said, it is a creature of that act. Just by way of example as to how the powers of judicial review can be exercised, I just refer to a recent decision rendered by the Bombay High Court, the Aurangabad bench. In that petition, incidentally, I was appearing on behalf of the petitioner. It was a petition filed by doctors or medical officers working in the public health department. They were challenging an action of the state government taken under Article 162 of the Constitution of increasing the age of retirement of only a class of doctors or medical officers from that department. It was contended before the High Court in that matter that this action of the government of increasing age of retirement of this group of officers was contrary to the statutory provision of law contained in the Maharashtra Civil Services Pension Rules. There is a provision which provides that the age of retirement of all government servants, but for class 4 government servants, the age of retirement is mandatorily required that is prescribed as 58 years. It was contended that when there is a statutory provision of law providing for the age of retirement, you cannot change that age of retirement by issuing an executive order under Article 162. So, therefore, this exercise of judicial review power, though permits the law to be set aside, there are some restrictions, as I said earlier. Now, as like the statute or law, as I said, in service matters, number of times it so happens that the courts are confronted with a challenge to a policy decision of the state government. Normally, in such matters, the defense being raised by the state government or the central government, for that matter, is that it is a policy decision and we are competent, we are armed with our powers to take policy decision, and the courts cannot interfere in policy decision or policy matters of the government. True, it is for the competent government, maybe the central government or the state government, to take a policy decision in the better interest of the public. But it is also open for the court to consider that if a particular policy decision is contrary to some constitutional provision, if it is ultra vires some constitutional provision, if it is dehors some statutory provision of law, if it has been taken by the authority in excess of the power conferred upon it, or even if such a policy decision is contrary to other policy decision like statutory decision or a larger policy decision of the state, then it is permissible for the court to interfere in it and to set aside that policy decision of the state. Apart from these things, it is also to be borne in mind that as far as the tribunal is concerned, now here I am not referring to the powers of the High Court, but as far as the tribunals are concerned, the service litigation, in service litigation, there is no power or you cannot file a public interest litigation in respect of a service matter. The tribunal is not empowered to entertain a public interest litigation in view of that was a decision rendered by the Honorable Apex Court in the case of Duryodhan Sahu, where the Apex Court has said that a stranger, a total stranger to this recruitment process or to the service matter, he cannot agitate that before an administrative tribunal. So holding that a stranger cannot approach a tribunal, and thereby saying that if a stranger is permitted to approach the tribunal, then it will open the floodgates. And the very purpose of formation of the tribunals for speedy disposal of service matters would be lost. Then, friends, apart from this, I would just like to mention that what are the frequently filed matters before the tribunals or the high courts in respect of service. The litigation in respect of recruitment is large as far as the matters regarding recruitment and reservation therein, like the vertical and horizontal reservation matters relating to that. And as I earlier referred, in regard to the disciplinary actions also, the matters are brought to the court. In regard to the disciplinary actions, I would like to just point out three major punishments in service law. Normally, they are provided. These are the three major punishments which are provided in service law. Those are of dismissal, removal, and compulsory retirement from service. Now, as a matter of fact, if we consider in totality, the result of all these punishments is one and the same, that the person is ousted from service. He ceases to be in service. But if we see it in closer details, we can see that there is marked difference in all these three categories of punishments. As far as the punishment of dismissal from service is concerned, in service jurisprudence, it is known as the capital punishment. And the reason is that a person who is dismissed from service, he loses everything. He doesn't get anything back from the department, no monetary benefits, nothing. And he cannot re-enter service. This is the most important aspect of it. And this aspect differs the punishment of dismissal from service with the punishment of removal from service. As far as a person who is removed from service, he can re-enter service of the same employer even. And as far as he is concerned, the competent authority, his appointing authority, has the discretion of giving him some terminal benefits. The discretion lies. So therefore, comparatively, while the punishment of dismissal is the worst punishment to be inflicted, the punishment of removal from service is comparatively lesser. And even then further is the punishment of compulsory retirement. The very nomenclature of it shows that it is compulsory retirement. So that is a retirement, but by way of punishment. So in that case, then, there is a particular minimum prescribed terminal benefit percentage, which is required to be granted, and the person gets that percentage of amount or the terminal benefits. So therefore, as I said, there are distinguishing factors in these punishments, and these matters very frequently come to the court. And as I said, even the matters of transfers and postings in recent past, they've acquired great importance. And the reason may be that the interference of executive or the political personalities or the other persons has increased in the matters of posting and transfers of government officers. And as I said earlier, the state of Maharashtra, where the act is introduced, in other states or the resolutions are holding the field. And as far as the provisions of act, if they are violated, the orders of transfers are required to be set aside. So in broad, these are the categories of the matters, and they provide a very good opportunity to the young lawyers who want to enter this field, and it is a very demanding and challenging field. So you can just study administrative law, have some basics about, or all the basics about the constitutional law, and enter this arena of service litigation, because this is a very good and demanding service litigation. And I would suggest that you can endeavor to come in this and give your best. So friends, this is what I wanted to convey about the service matters, service litigation. And I again thank the Lex Discourse team, especially Harshita and Akshay, Prasad, Akshay. There are two Akshas, in fact. I would like to thank all of them. And thank you very much. All the best to you, all of you. Thank you very much.
Thank you, sir, for your insightful address. So we have some questions from our attendees. May I pose them to you, sir?
Hello.
So we have some questions from our attendees.
Yeah, please.
Yes, sir. So the first question is whether the contract employees working under the contract but working for the principal employer, that is state government or local bodies, can approach to the Maharashtra Administrative Tribunal. Is there any case law to that effect?
No, as far as contract employees are concerned, if they are employees of the state government, they can approach the tribunal, even if they are on contract basis, because they are being employed by the state government. But as you said, if a contract employee is working under the local self-government, as I mentioned earlier, the local self-governments are not presently under the purview or within the jurisdiction of the administrative tribunals. So if a contract employee is there under the Jilla Parishad, for example, or a municipal corporation, then he cannot come to the administrative tribunal. The remedy lies, the remedy is available only for a contract employee, even a contract employee of the state government.
Thank you, sir. So the next question is whether Zilla Parishad employee can approach Maharashtra Administrative Tribunal. If yes, on which occasions and which class of employees can approach?
No, as I said just before some time, the employees of Jilla Parishads, because they are under the local self-government, they can approach the administrative tribunal if and only if their respective government has issued a notification under subsection 2 of either the section 14 or section 15 of the Administrative Tribunals Act. Unless that notification is issued, but in a case, suppose in a state, a notification is issued under subsection 2 of section 15, that person can approach, certainly. But as I gave you the example of our state, the state of Maharashtra, we have no notification issued by the state government under section 15.2, and therefore Jilla Parishad employees are not permitted to come to the administrative tribunals.
Thank you, sir. So next question is, what was the trigger point when you decided to focus your area of practice to tribunal or service matters, more particularly when you had a legacy of criminal law at your home?
The answer to this question is probably destiny wanted to happen it like that only. When I had joined my father's chamber, my elder brother, who is now a designated senior counsel, he was already in the chambers. And in 1989, when I had joined bar, the tribunals were not in existence in the state of Maharashtra. But immediately then, after within a year or two, in 1991, as I said, the tribunals were established. Initially, we didn't have a bench in Aurangabad. We were required to go to Mumbai, file the matters, and then get orders from there and come back. So probably in that situation, the mantle fell upon me to move to Mumbai as and when required. And probably that way it happened that I accidentally concentrated on the service litigation.
Thank you, sir. Whether contract employee can approach to tribunal for permanency is the question posed by one of our attendees.
Yeah, in fact, contract employee per se has no right to claim permanency. But in recent past, there have been some decisions rendered by the courts to a certain extent saying that if certain contingency or if some conditions are fulfilled, because it so happens that these employees are continued in service for years together, 10 years, 15 years, 20 years. And when they are nearing the age of retirement, they are told that, no, you are not a permanent or regular employee, and then you will not be entitled for service benefits, any service benefits for that matter. So nowadays, there are some courts which have taken view that, yes, the employees are required to be regularized in service.
Thank you, sir. One more question, sir.
Please.
At what extent the Evidence Act is useful in service matter proceedings?
No, as I said, actually, Evidence Act may not that be applicable in service proceedings or departmental inquiries, because The courts, as I said earlier, are exercising the powers of judicial review. And as far as the departmental inquiries are concerned, after the departmental inquiries are conducted, once the inquiry is over, the evidence is closed, the inquiry officer drafts his report, submits it to the disciplinary authority, and then the disciplinary authority takes the final decision. Thereafter, when the matter comes to court, the courts are not in a position to look into the niceties of the evidence record. And the reason is because that person has a statutory remedy of appeal already provided. Of course, not before the court, but before his departmental authorities. So as far as the provisions of the Evidence Act are concerned, they are not attracted in these matters when the matters are brought to the courts.
Thank you, sir. So we have one more question.
Yes.
Under labor laws such as Factories Act and Plantation Act, a minor above the age of 14 and 12 years respectively can be employed as workers. Aren't these in contravention with the spirit of the Contract Act? How are the service conditions of such minors regulated to ensure they are not being exploited?
No, the very fact that they are minors, the age is still mentioned by you. In the first place, these employees, these kids, I would call them kids. It is not proper for employing of these kids even in the temporary manner also. But if such situation arises, then it is for the competent authorities like the labor authorities to take appropriate action in these matters.
Right, sir. So thank you, sir, for enlightening us on the session and also for answering the queries and questions. Thank you so much. There is a small announcement for before concluding the session. Lex Discourse is delighted to announce its next webinar on 21st of June 2020 at 11 a.m. by Honorable Shri R.M. Borde, retired Judge, Bombay High Court, on the topic Scope and limitation of writ jurisdiction under Article 226 and 227 of the Constitution of India. I would like to express my sincere gratitude to Advocate Avinash Deshmukh sir accepting our invitation and for enlightening us on the topic in the lucid manner. And thank you so much, sir, for your valuable time.
It was my pleasure. It was my pleasure to be with all of you. Thank you very much.
Sir. Thank you, sir. Lastly, I thank our attendees for attending the webinar and making it a success. Stay home, stay safe.